Hello and welcome to a special episode of 5-Minute Family Law. I was going to use this time to talk about becoming parents, but I've just finished preparing for a webinar that I gave for the Continuing Legal Education Society of British Columbia, in which I looked at all of the cases accumulating from across Canada about COVID-19 in the context of family law. And so I thought I would talk about that while the iron is hot and I'm still remembering what these cases have to say. A couple of things. First, my research ended on the morning of April the 21st, 2020. So if there are new cases that came after the morning of April the 21st, I haven't reported them and I'm not going to be telling you about them. Second, this is going to be an unusual episode because I'm going to be talking about a lot of case law. And when I refer to a case, there's going to be a little title at the bottom of your screen that gives you the name of the case and the neutral citation of the case. And you can use the neutral citation to find the case on the website of the Canadian Legal Information Institute. Now, almost all of these cases have to do with people who are applying to the court to continue a parenting schedule that's been given to them by an order or by an agreement, or people that are looking to suspend someone's parenting time under an order or an agreement. So that's the context. So let me start with the first case, which is a case out of Ontario called Ribeiro and Wright. And it's probably one of the most important cases because as of the morning of April the 21st, it had been cited in 44 other cases, which is a really good indication that lawyers and judges are paying attention to that case. And so here are the things that the judge had to say. First of all, there should be a presumption that existing parenting arrangements and schedules should continue, despite the fact that the coronavirus is here, subject to whatever modifications may be necessary to ensure that all COVID-19 precautions and protocols are adhered to. The judge said that when you are applying to court for an order, changing an order or an agreement for parenting time, that the person who is starting the application will need to provide specific evidence or examples of behavior or plans by the other parent that are inconsistent with the COVID-19 protocols. The judge said that the parent who is responding to an application like that will need to provide specific and absolute reassurance that COVID-19 safety measures will be meticulously adhered to. And both parents are going to be required to provide very specific and realistic time-sharing proposals which fully address all COVID-19 considerations in a child-focused manner. And while I'm giving this presentation, you'll see me looking at this piece of paper here, and this is something that you'll be able to find on my website, and I'll give you the address at which you can find this. But it's there, and you can download this for yourself. The judge also said in the Ribeiro case that judges will not need convincing that COVID-19 is extremely serious. In fact, this is one of those things that all of the judges all across Canada are well aware of. Next, in another case called Onwoha versus Onwoha, the court was dealing with an application for an order that a child be returned from Canada to a different country. And the court made a comment about what qualifies as urgent, because the court will only hear urgent applications in the time of the coronavirus. The court said that the determination of urgency is intended to be simple and expeditious. The determination is made without prejudice to either party on the substance of the motion when it finally gets heard. And what without prejudice means in that context is it means that the judge isn't making a decision about the merits of the underlying application that you're making. The judge is just deciding whether or not something is urgent or not. Next, there's a case called Thomas and Wolleber, in which the court also talks about urgency. And this is important. The court says the concern must be immediate. That is, it is one that cannot await resolution at a later time. The concern must be serious in the sense that it significantly affects the health or safety or economic well-being of the parties or their children. And the concern must be something definite and material rather than speculative. It must be something tangible rather than theoretical. And it must be one that has been clearly particularized in the evidence. And all of that is a fancy way of saying that the concerns that you bring to the court have to be immediate and pressing. They have to be a problem now. You have to be able to tell the court about concrete concerns, not concerns that you might have just because you're worried about something, but about a concern that's about something that's actually happened. And then one of my favorite quotes from this case is the judge says, quote, "Right now, families need more cooperation and less litigation." Well, I can't agree with that more. The next case is a case called Lee and Norris. And in this case, the court talks about how, in this case, the mother's concerns about the coronavirus and the chances of a child getting exposed to the virus can be addressed through responsible adherence to the existing court order. And then later on, the judge says, what do I mean by responsible adherence? I mean being practical and having some basic common sense. Physical distancing measures must be respected. The parties must do whatever they can to ensure that neither of them nor the child contracts coronavirus 19. Well, fair enough. Next is a case called Scoose and Scoose. In this case, there was a consent order. And the mother just decided that she wasn't going to allow the father to see the children as the consent order required. There is a consent order. The mother has chosen not to respect it. She has engaged in a self-help remedy despite a clear consent order that was filed a few days ago. The court cannot be seen to condone this type of behavior. Without citizens obeying existing court orders, the whole justice system would be turned over on its head, which is a way of saying that if there is an order in place, you have no choice except to comply with the court order. And this is important because when the judge is talking about self-help, the judge is talking about parents who just simply decide, no, you're not going to see the kid because I'm worried about the coronavirus. The thing is, when somebody has parenting time under an order or an agreement or an arbitrator's award, there are ways that are established under the law where you can apply to court to vary or change the agreement, the award, or the court order, and you're supposed to follow those things. And if you don't do it, the court's going to see this as you helping yourself to a remedy, and you have to be careful about that because that's breach of the agreement, breach of a court order, or breach of an arbitrator's award, all of which can get you into some pretty serious trouble. So the court here is just saying, if there's an order in place, you have to obey the order, and the court has no choice but to enforce them. But the court also makes a point in this case that one of the reasons why parents should comply with orders and agreements and awards about parenting time is that it's good for the kids. Uncertainty and lack of direction can add further havoc to the lives of children who are the most vulnerable when parties are unable to resolve matters. The children need and deserve stability, comfort, and predictability in their routine. Despite the current world events, this can be accomplished. The next case is a case called Tessier and Rick. And in this case, the mother was applying to suspend the father's time with the children. And what the judge points out here is that it's the mother's application to suspend the father's parenting time, and therefore the burden to show that that's the appropriate result. And what I mean by that is the legal onus. The person whose job it is to prove that that's the order that should be made is on the person who's making the application. In this case, it's the mother. So the judge says the onus, therefore, is on the mother to provide specific evidence or examples of behavior or plans by the father that are inconsistent with COVID-19 protocols and expose the child to risk. On that theme about how self-help is a bad idea, another case called Amati versus Kalashi, the court says, the mother is not permitted to simply engage in self-help or to interpret public health directives as a license to terminate parenting time. Fair enough. Another case called Belbonton and Luwawa talks about this idea, and it's a recurring theme, that parents have an obligation to grow up, act in a mature manner, and talk to each other about what they're going to do to minimize the risks their children are exposed to. And the court says this, good parents will be expected to comply with the healthcare guidelines and to reasonably and transparently demonstrate to the other parent, regardless of their personal interests or the positions taken in their parenting dispute, that they are guideline compliant. And the court says later on, a parent's failure to communicate and meaningfully cooperate where a child's safety and well-being are involved is a failure to parent. And that's important because a lot of these cases that trigger someone's application to suspend someone's parenting time or cause someone to simply withhold it without getting permission from the court first, a lot of them are caused because the parents weren't talking to each other. One parent was sending emails to the other saying, well, this is what I've done. What are you doing to complying with the healthcare protocols? Are you complying with the requirements to maintain social distancing? Are you staying in your home? Are you trying to minimize the amount of times that you're going out to the grocery store? Are you making an effort to go to the grocery store at off-peak hours? And the other person just isn't talking to them. They're not answering. And so in a case like that, it's easy to see how somebody's tail gets twisted. And of course, what are they going to do? Because if you're not going to talk to the other parent to talk about how you are observing and complying with the public health care protocols, well, that's leaving the other parent in a really tight position where they don't necessarily have a huge and meaningful wide range of options. And so it's not surprising that some parents would help themselves to a remedy. In a case out of British Columbia called JW and CH, the court again talks about what does it mean for an application to be urgent. And the judge says, to be considered urgent, there must be some issue of immediate concern. And the judge says that examples of this include an imminent plan to relocate with a child or to remove a child, an imminent or recent threat of family violence, an imminent threat that a party may be arrested or committed to jail, or an imminent risk of irreparable harm, including undue financial loss if an application is not heard. And so what the judge is emphasizing there, it's along that theme that we've already heard of before about problems being real and tangible rather than speculative or hypothetical. And what the judge is emphasizing is that this has to be a problem that the court has to deal with right now. It just simply cannot wait until the courts reopen after the coronavirus. Oh, and then one of my favorite decisions is a case called McNeil and McGuinness, involving what appear to be a pair of parents who are in extraordinarily high conflict with each other, and a judge who, quite frankly, has had it up to here with that kind of crap. The judge says, I have no idea if a mere recommendation will have much of an impact, so perhaps I can go one step further. Perhaps I can give high conflict parents a bit of a warning. And then the judge continues, just because the judge deciding whether something is urgent or not decides an issue isn't urgent, it doesn't mean the issue isn't important. It simply means that the court has to prioritize which issues they currently have the resources to deal with. We are counting on parents to be fair and helpful with one another, to rise to the challenge and act with each other in good faith. Because now, more than ever, children need parents to be mature, cooperative, and mutually respectful. In these times of unspeakable stress and anxiety, children need emotional reassurance from both parents that everything is going to be okay. How parents conduct themselves during this time of crisis will speak volumes about parental insight and trustworthiness. Your reputation will outlast COVID-19. So please don't try to take advantage of the current situation, and in the long run, self-help will turn out to be a big mistake. So those are words to live by, and what the judge essentially is saying there is that if you misbehave and do things like act unilaterally, this can come back to bite you in the ass once the COVID-19 virus is concluded and the other parent is taking you to court looking for a finding that you've been in contempt of court or fines or all the other things that are kind of attached to that. Next, in a case called McNulty and Graham, the court says that the simple denial of contact, contrary to an agreement or an order, is sufficiently grave that an application to enforce will be considered urgent. The court continues on and says something that almost all the other judges have said. There is a presumption that this order should be respected and complied with. Carrying on, another case called Trudeau and Auger. The judge says, the judge is talking about cases that might justify the withholding of parenting time. Some circumstances that may justify a suspension of parenting time in the future could include evidence of a disregard for the safety and well-being of the child by the father, by disregarding the directions relating to COVID-19, and the judge is talking about the public health protocols. Specific medical evidence relating to the child that access to the father would place the child at significant risk, and specific evidence relating to the increased risk within the child's community and the risk of the child traveling from his home to the father's residence. So, as you can guess, in this particular case, it was a case involving a mother who had withheld contact between the child and the father was applying for the restoration of the contact. In another case called Haywood and Jalad, the court emphasizes the underlying fact of all of this, which is, quote, "This court's only concern is the safety and best interests of the child." And the best interests of the child is the core mandate that courts and parents have when they're making decisions about children. It's something that you'll find in the Provincial Family Law Act, and it's also a clear direction in the Federal Divorce Act. In another case called Tigert and Smith, the court is explaining why it is that orders and agreements are presumed to continue in force. The judge says the rationale for continued parent contact is that under the existing order, it is presumed to be in the child's best interests. In other words, the contact between a child and a parent that an order or an agreement provides is presumptively in the child's best interests, and therefore that is something that is intrinsically worth enforcing by the courts. In a case called Cooper and Tenike, the court is talking about the obligation of parents to grow up and work together and says, "This is a circumstance," referring to the COVID-19 virus, "that demands the best of parents and requires them to work together, no matter their differences, to craft the safest options for children while ensuring that children derive the benefit of the love, nurturance, and guidance of both of them. Of course, the overriding requirement on parents is to keep the health, well-being, and best interests of their children at the forefront of their decision-making." Now, in this particular case, the children had been withheld from the father, and the father was also asking the judge for something called a peace officer enforcement clause. And the idea with that is that the judge makes an order that says, I am directing that any peace officer who has jurisdiction take steps to enforce this order. Cops don't like those orders, and judges don't like to give them. But in this case, the judge says, in this case, a police enforcement clause as sought by the father is no solution. This would cause significant stress on the children and is not appropriate in the circumstances. Police enforcement is not what is urgent at this time. What is urgent at this time is that the mother and this father work together to adapt and shape their existing parenting order to work in the current circumstances. Next, there's a case called Lyons and Lawlor, and this is an important case because the child had asthma, and asthma is one of those conditions which make contracting the coronavirus particularly scary because the coronavirus is a lung problem, right? And if you have asthma, you already have lung problems. The judge says, the applicants believe that the child is at particular risk as a result of his asthma. However, there is no medical opinion from the family doctor confirming this, or that the child requires more invasive distancing efforts to keep him safe. Direct and compelling evidence from his doctor was not provided and would be required to support that conclusion. So what the judge is saying here is that asthma is serious, but in line with all of those other cases that talk about the importance of coming to the court with concrete evidence, the judge here is saying, I needed to have medical evidence in order to believe that firstly the child has asthma, and that the asthma is a particularly important condition in light of coronavirus. The judge may very well have made a different decision than the judge did if that kind of evidence had been provided. In a case called Feldman and Knight, the judge gets back to that theme about warning you against helping yourself to a remedy and says, when the applicant unilaterally withholds access, he is breaching that court order. Such disregard of an existing court order will not be looked at favorably by the courts once normal court operations resume. And that's a pretty blunt warning that if you breach a court order now, while you may not be held to account while the courts are closed, when the courts are open, that very well may be what happens. Another line along that theme and about how the existence of the coronavirus isn't an automatic excuse to suspend parenting time. In a case called Tudor Price and Salia, the judge says the unilateral actions of the mother should not be condoned by this court. A party cannot use the new temporary reality of the COVID-19 pandemic to revisit trial results with which he or she may not be pleased. And before I get to a summary of the highlights of what we've just talked about, I'll just address one last case. This is a case out of British Columbia called SR and MG. And this case is important because what had happened is that the father had suspended the mother's access. The mother was an LPN working at a hospital which had coronavirus patients. And so obviously the father was concerned that because of the mom's occupation as a frontline medical worker, that she was more likely to be exposed to the coronavirus, and therefore the child was as well. And the judge says, find that there are a constellation of factors to consider in deciding what the child's best interests are. A, whether the child is at an elevated risk of suffering the more severe consequences of the virus. And so what we're talking about there are children who are especially young, children who have asthma, or children who have other pulmonary problems. B, whether either party or those in their household are at an elevated risk of suffering the more severe consequences of the virus. And there, what we're talking about are not just the children, but the people with whom the children live. And this is important because the people that are at an elevated risk are obviously the elderly, people with existing lung problems, and people with compromised immune systems. C, each party's exposure to the risk of contracting the virus, and obviously the mother in this case was at a high risk because of her job. And D, the steps taken by each party to mitigate the risk of exposure. And in this particular case, the mother had gone above and beyond even the protocols prescribed by the hospital. And ultimately, the judge decided not to suspend the mother's contact with the child. And now, I'm just going to review quickly the highlights of what we've talked about. Lessons from the case law to date about COVID-19. If you have an existing order or agreement with which you are not happy, remember that the cases so far say that there is a strong presumption that existing orders and agreements should continue in force, subject to whatever modifications are necessary to ensure that COVID-19 protocols are observed. The courts have said that these parenting arrangements can continue to work if parents exercise common sense, work together, and follow the protocols. Bear in mind, however, that the court will not condone people simply disregarding orders and agreements that they've decided that they don't like or are no longer convenient. Self-help is not an option. Orders for parenting time are presumed to be in the children's best interests. So, the COVID virus is here. Can't you just simply stop the other parent from seeing your children? Well, what the courts have said is that the existence of the coronavirus on its own isn't enough to just simply end a parent's time with a child. You need something more, like proof of a concrete risk or hazard to the child, before the court is going to suspend the other parent's parenting time. But bear in mind that uncertainty, lack of routine, and not seeing a parent can add havoc to children's lives at a time when they are most vulnerable. They need the stability, comfort, and predictability that parenting arrangements provide. Remember that the case law says that the simple existence of the coronavirus and the coronavirus health protocols is not a license to terminate someone's parenting time. You need something more. The courts have also warned that if you decide to act without following the proper legal steps to vary an order or an agreement or an arbitrator's award, that decision will likely come back to haunt you when the courts do reopen. If you do have to go to court because you need to suspend someone's parenting time or otherwise change or enforce an order, remember that you're going to need to come to court with some pretty specific evidence of concrete examples of that person's failure to comply with COVID-19 protocols. You need to talk about concrete problems that you're having, not mere worries that you have that are speculative or theoretical. And when you come to court, you're going to need to make a specific and realistic proposal about how parenting time can continue in a way that addresses the COVID-19 protocols. Remember that the court's only concern is the well-being and best interests of the children and their caregivers. If you do have to go to court, you will have to prove that your application is urgent, because the courts are only hearing urgent applications. That means that you will have to show that you have an immediate concern that simply cannot wait. The concern you have has to be serious, it's got to be real, and you will need again to give specific, concrete examples of behavior that supports your concerns. The kind of urgency we're talking about are risks to the health, safety, or economic well-being of the children or the adults in the children's lives. But risks to the economic well-being can include a risk of financial harm that is irreparable, meaning that it cannot be undone after the coronavirus pandemic has gone away. Remember also that breach of an order may constitute urgency all on its own, especially if the children are likely to suffer as a result of the breach of the order. However, if you can't go to court, the courts have also provided some concrete advice. The courts have said that you need to comply with the COVID-19 protocols, and that you should tell the other parent what you're doing and ask them what they're doing to comply. You need to talk to each other like adults to figure out what each of you are doing to ensure that the children are as safe as possible. You need to be practical and exercise common sense to work with the other parent to figure out sensible, practical solutions that will work for both of you. And if you can't agree about the meaning of a protocol or a healthcare concern, talk to your doctor or call 811. And if you can't resolve a problem, but you also can't get into court, then you should certainly consider hiring a mediator or an arbitrator who can help you resolve disputes remotely using video conferencing tools. And finally, I want to give you some of my favorite quotes from the case law to date. Right now, families need more cooperation and less litigation. How parents conduct themselves during this time of crisis will speak volumes about parental insight and their trustworthiness. Your reputation will outlast the pandemic. The pandemic is a circumstance that demands the best of parents and requires them to work together, no matter their differences. Parents are not permitted to simply disregard a court order just because they think they know better. Finally, a parenting order is not a suggestion, nor is it a recommendation. It is a command and a direction that must be obeyed. Compliance is not optional.